stakeholder who is a corporate officer or a partner. All right, and then there is something that customs loves to test you on. Okay, so highlight it, underline it. Penalty amount for each false statement of material fact is $5,000. Okay, $5,000, but the maximum penalty is $30,000. So in a way you get a deal, right? So let's say you made 6 statements of material fact, okay? False statements of material fact. The customs can fine you for $30,000 because 6 times 5 is 30, right? What if you made seven statements of material fact? You get 1 statement for free, right? Okay, so it's a deal. And this is important. $30,000 is a ceiling. You'll see it throughout, because if customs officer extends you the penalty notice for $35,000, you can say, wait a minute, maximum is 30,000. How can you do that? You cannot. Okay, get it down to 30. So those are the numbers which I have seen tested. All right. So let's say, and this goes back to my recommendation to any students, because I have we as people, we are not perfect. Okay, we we get in trouble from parking tickets to some kind of accusations. So if any one of us has skeletons in the closet, usually they look at this the customs broker responsibility section, and they look at this as, okay, 10 years ago I did this, okay, 10 years ago I was convicted of DWI, okay, or did some shoplifting or whatever, okay, look, this is very strict, I will not be able to make it, so why even try, why even bother this, okay? Well, before, and this goes out to everyone, before even considering withdrawal, okay, this moral character thing is based on the totality of circumstances, but pay attention to this. Let's say you are denied the license, okay, let's say customs investigating officer makes a recommendation against the license, granting the license, and suppose you pass, you made all the knowledge requirement, you pass the examination, you pay all your fees, and you otherwise qualified, you got issued denial, you have to be given a reason, okay? If you are granted, there is no reason need to be stated, right? So let's say I passed the examination, they don't tell me, when I passed the examination, they never told me the score, okay? But if you fail the examination, I think you're entitled to knowing what you did wrong. So at the very least you can appeal. At the most you can appeal. At the least you know what you've done wrong. Okay, so that seems to be fair, right? But let's say in the situation of license denial, let's say you've been rejected. There is 3 levels, at least 3 levels. I can think of 4 levels, okay, and possibly the 5th level of appeal. So first level is assistant commissioner. Remember when, guys, can I erase this? It's okay. So remember, I mentioned the level of each authority, and the top guy in the customs. Well, let's put it this way: top guy in customs is called commissioner. The guy who is underneath commissioner is called, of course, his assistant. Okay, this is CBP. Okay, so you can ask the deputy boss of the customs, okay, to actually have a second shot. You tell him, listen, Mr. Assistant Commissioner, I'm changed. Okay, it's been a long time ago. Whatever I've done is in my past life. I did my fair share of service. I've done community service. I've been going to church ever since. I'm a changed person, and because of that, I believe I should be given an opportunity to to have a chance to continue my career in this field, and I've done all these requirements. Otherwise, I'm qualified. Okay, and HTSUS commissioner reviews everything, and it can be done by personal appearance or in writing. Okay, or both. I'd request both. Okay, I put in a letter saying these are the reasons. I put something like a memorandum, and I would request a personal appearance to make an argument, to come in and say, listen, this is very important for me. Okay, so because in person you can also appeal to emotions, unlike you can do that in writing, but to a lesser degree. So there is that level. Let's say the assistant commissioner says no still. Okay, then that you can go up to secretary. And secretary, as we mentioned, it's a department. He works for the Department of Homeland Security, so that would be his boss. Okay. So that's the second level of appeal. And you can pretty much do the same thing. Okay. And keep in mind, for the customs broker examination, what are the questions that the customs will ask you? They will look for the 60-day rule. Okay. They will say the appeal must be made within, and they say 90 days, 30 days, 60 days. Okay, so highlight that 60 days. That's why it's underlined. So let's say Homeland Security says no. Remember when I mentioned way back in the first day, way back, it was only last week, that we have executive branch and we have judicial branch, and judicial branch checks on the executive branch. Well, you can go to One Federal Plaza right here in New York, to the Court of International Trade, and you can ask the judge to say, Judge, these people are being not fair to us. Okay, I'm being unfairly treated. This is my argument. I think I deserve to have a chance to have a license. Okay. So, and the judge will not be associated with either Department of Homeland Security or with Customs and Border Protection. His duty is to be fair, and his duty is not to be biased. So there is a chance that at that level, the judge may say, okay, I think you deserve to have a license. And if that's the case, whatever Assistant Commissioner thinks or whatever Secretary of Homeland Security thinks, it's irrelevant. They must go by what the judge says. Okay? Again, 60 days. Okay? Appeal action is commenced 60 days. This is where it stops, okay? But what's not mentioned here is, of course, if the judge of Court of International Trade thinks you are incorrect, you can also appeal it to the federal level, to the Court of Appeals for the Federal Circuit in Washington, D.C. And if they don't agree with you, you can appeal to the United States Supreme Court. So, but this is beyond. Most likely, it will not get there. Okay, this is beyond. This is beyond the topic. For your purposes, just keep in mind every appeal stage 60 days, 60 days, 60 days. Okay, and what type of days? Keep in mind calendar days. Okay. So here is an interesting note. An applicant who has been denied a license may reapply at any time. Well, yes, that's true. They may reapply at any time, right? But that still doesn't mean that if they wait more than 3 years, they don't need to pass to pass the examination again, right? So what this statement applies, yes, they can apply. So let's say I've been denied license. I submit my application. If more than 3 years have passed, okay, I take my license. I take my application for the license. I need to pass the examination one more time. Okay, so if it's within a 3-year block, I can submit applications all the time. Okay, usually by the time after you go through the appeal, it will be more than 3 years. So you can again go through this, and there is nothing that prevents you from doing this. Okay. After 5 years, you show again that you're a good citizen, let's say. So if you've been denied on a moral character grounds, they will look, okay, look, for 10 years, this gentleman or a person or a lady has been a good person, okay? Another 5 years, still a good person, okay? Parking tickets at most. Why we should deny this, okay? So this rule, and it's codified in 111.18, says it can be done at any time, okay? Provided that the prerequisites are met. Okay, now we get to the interesting topic. What I talked about before, what is customs business, okay? And we mentioned things which are not customs business, okay? Such things as the filing a protest, for example, is not customs business for the purposes of this section. But let's look at what customs business is, okay? First bullet point, entry. And remember, I mentioned entry is another big topic that we will cover. By entry, that's what pretty much I think whatever it encompasses is what is stated here. Most likely, this bullet point by entry means you assemble the paperwork, you fill it out, and you file it with customs so the products can clear. Okay. Admissibility of merchandise. Okay. Admissibility of merchandise is you determine whether the product is over that. Let's say it's a quota product. Okay. If it reaches quota limit, the product is not admissible. All right. For consumption, let's say. You determine that, you engage in customs business. Valuation, we'll be talking about that later. Okay, how much does it cost? Okay, I pay $3 for the marker. Okay, but to manufacturer, it costs $1 to make this marker. It's only I pay the $3. Okay, can I make a declaration of $1? Because that's what it costs to manufacture to produce it. In other words, sometimes if you will be doing customs, sometimes you will see two invoices. One invoice is for customs purposes, is clearly marked, and another invoice is the commercial invoice, the one that you actually pay. Okay. Well, how can you lawfully make two invoices? How can you lawfully have double accounting? Okay. Well, this is a question of valuation, and whether you can do that or not is also considered to be a customs business. Payment of duties, taxes, and other charges, of course. You have to calculate whether free trade agreement applies, whether country of origin applies, and how much duty you owe. Taxes. Sometimes you have to pay a tax on top of that. I mentioned in my microwave example that there is a fee related to the ozone depletion layer. If you have a fishing equipment, if you have alcohol, you have to pay taxes at the time of entry. So how you determine that? Okay. By the way, customs, if you don't, let's say you don't pay microwave taxes, okay, because it's a different agency, it's IRS, okay. I've seen these situations where you can get away. You just pay duties, and you can take a microwave, okay. So you determine that no taxes are eligible at that time. Well, customs can come back to you and say, well, we think you owe taxes because it's a microwave product and microwaves deplete ozone layer, for example. So how you figure out how to go about it? That's a customs business, okay? Preparation of documents, well, that goes back to the entry. And notice this is a killer. Any activity that relates to the above. So any activity, so by talking about the broad scope of entry, of figuring out the logistics, figuring out the paperwork, figuring out structuring the transaction, okay? Any activity, okay? I make a phone call, I ask for your advice, okay? If that activity relates to any of this stuff, like classification, is this marker made of paper, or I mean made of plastic, or made out of something else? I can't think of anything else that a marker may be made of. But let's say sometimes pencils are made out of plastic or made out of wood, okay, like mechanical pencils. So this is classification. It relates to the activity. You send out questionnaires, okay, because it relates to the classification. It's customs business, okay. So the point is it's very broad. Okay, so the good question will be to ask is what is not customs business, okay? And well, I mentioned that there is a ruling procedure that clarifies. Regulations do say something about what is not customs business, and they make a point of two things. First is electronic transmission of data. So let's say you hire an IT company, and they have servers, and all I do is I fill out the paperwork online, okay, and through the cloud I send this data to customs. So they receive it, they look at it, and they say, okay, you can go through. Okay, that's just electronic transmission. That IT company is staffed by computer techie guys. Okay, computer techie personnel. They have no idea about customs business whatsoever. Are they required to have a license? No, because what they do is they just facilitate the transmission of data. Or you have a person on site who just press send button. Okay, that's electronic transmission of data. So that's not customs business. Yeah.
Does that also include importer security filing?
Importer security filing. So the question is, can ISF, importer security filing, is it considered to be customs business? Okay. Usually, usually the import security filing is a set of data that you must send to customs before the things leave certain destination, and there is a time limitation criteria for whether the shipment is air or whether the shipment is sea. Okay. Several parties usually transmit data. Most of them are the two parties. One is a freight forwarder / customs broker. Okay. Another one is the steamship line. Okay, or the freight operator. So the freight operators, they are not customs brokers. They do not have a license, but they transmit data. Okay, so and they do that on behalf of their clients, and they do that all the time. So the question is, can they do that? Because they do that, to me it tells that it is outside. It is kind of like filing a protest. Okay, but you have to be careful, because what if you are a customs broker and you use I think there was a ruling on this, because someone was seeking to clarify, because you then take that data and you use the same data to clear the entry.
Right.
Okay, if you use that same data, if you kind of combining your task, okay, and it can flow over into the customs business, then you have to have a license. Okay, so there is that fluid line. Okay, if you're doing just merely for 10 plus 2 or the 10 part, not
right.
plus 2 part,
Right.
then no. If it's you're going over,
Yeah.
and doing clearance, then yes.
Okay.
Okay. We should have time I scheduled toward the end of the class to talk about the import security filing. It showed up substantially on customs broker examination when it came out, I believe 2010 or 2008 to 2010. You saw a lot of questions on the customs broker examinations. Now it's subsided for the past I think 3. Were there any questions on the last? Yeah, I haven't seen it. So it's been big. Now it's kind of subsided. So to my understanding, it was kind of thing of the moment. Okay, so it was big at the time. So examiners felt like it should be on the examination. Now it's not as hot or sexy anymore. So they went away with that. Okay, so this is electronic transmission. Now, corporate compliance activity. Corporate compliance activity, what is this? And on the next page you will see a little drawing, okay, of the smiley faces. And there has been issues with the corporate compliance activity, and this relates to the group of companies when you have one, when you have two or more companies, and that is the way it's usually done. Many businesses today are organized, and you can see that, for example, in the retail industry, you have Walmart and you have Sam's Club. Okay, they're owned by one company, probably by some holding company, which is owned by some other company. So you have this holding company structure, and oftentimes you find it very expensive to keep compliance stuff for the Walmart and compliance stuff for the Sam's Club, let's say, or for the company 1 and company 2. So what has been done is at the turn of the century, the early 2000s, okay, so this is relatively recent. At the turn of the century, they introduced a new concept where one company can help the other company to do certain things. So let's say I work in the Walmart, okay, and Sam's Club imports certain tables, okay, and I need, so Sam's Club comes to Walmart, a related company, and they say, what is the classification for the tables? Can you tell us what is the classification? How should we determine the duty rate? Okay, and they go to the compliance department of Walmart, and they fill out, they go through the procedure, they determine the duty, they determine the classification, then they send it to Sam's Club. Okay, now theoretically, so if you think about it, we talked about the classification is a customs business, okay, before. Now theoretically Walmart is doing customs business for Sam's Club, okay, theoretically. Now Walmart doesn't have a license to do this. They import it for themselves, let's say. They are not licensed customs broker, but they have specialists who do that. How can they do that as a corporate entity? Well, they do that pursuant to the corporate compliance activity exception, which is not customs business, even though they deal with customs stuff all the time. Of course, there is a criteria for that, okay? So they can get away with it as long as there is a 50% of ownership or more, actually more. That means that if you're 50%, no. If you're 50.1%, then you can do it. So if Walmart has 50.1% ownership in Sam's Club, everyone knows Sam's Club, right, here? I'm just using it as an example because it's common throughout the landscape of the US of A. Then, yes, Walmart specialists, customs compliance department can advise Sam's Club on classification of its commodities. So in other words, they can lawfully outsource it, okay? Now, can they, how much can they do that? How much of activities can they do that? This has been a subject of debate, and they even did some rulings on this, okay? Because the regulations themselves didn't clarify this. So you have, for example, Walmart filing its own entries, okay? Can you Walmart file entries on behalf of Sam's Club? This is where the customs drew the line, and they said no, okay? You cannot file entries, okay? Which means under rubric 1 prepares customs documentation for company 2. You cannot prepare documentation and you cannot file documentation. But see, here is a conflict. You prepare documentation, right? What's the difference between preparing documentation and providing information? Okay, by providing information, you can provide information through preparation of documentation. So there is a conflict with that. That conflict has not been resolved, and if you are confused, welcome to World of Customs Broker Examination. Okay, this is the first thing that I'm not able to draw exact strict line, except for the saying that if you provide advice without filling stuff out, okay, without preparing it, you don't prepare it, but you actually facilitate it, okay, then it's okay. If you actually take the 7501 or you take other documents and you prepare it for signature if Walmart prepares it for signature of Sam's Club, then that's incorrect. But if Sam's Club asks, what should I put for line 1? Okay, can you please tell me? I do it myself. And the Walmart says, on line 1 you need to put 5709 30 30 30. Okay, 5.7%. It's just as an example. Then that's okay. Okay, so there is that thin line that you sort of have to keep in mind whether determining whether it constitutes customs business or not. Okay, so we just talked about the exception within customs business. Okay, now we're gonna move on to the topic which discusses even you're doing customs business, you can still do it without a license, because there are situations when and I had students who sit down and like, oh, that's what I wanted to do all along. I don't need a license for that. I said, okay, what are you doing in this class? I was like, well, thanks. Good thing that I took this class. Now I know that I don't need a license. Okay, and in that case, the person was, I believe, a forwarder. So first thing is transaction on one's own account. If you do it for your own, if you import pencils, if you import computers for yourself, let's say you're the Walmart, okay, or the Target, and you import it for yourself, you can clear customs without a license because this is for you, okay? And you're not doing it for other, but you're doing it only for yourself. No license is required. Okay. Next one, and this one is kind of tricky. If you are the employee of the broker and you are doing it for the employer, so you fill out W-2, you come to work, you punch in, you punch out, you get your hourly paycheck, okay? You are under control and supervision of the licensed broker who tells you what to do, who oversees your work of employment, or scope of employment, then you can do it. You can do customs business if your boss has a license and that boss gave you the authority to do certain things, such as sign the documents, and on the next page called transact other customs business. Okay, so whenever you what this line talks about is the behind of scenes things that if you ever become employed by the customs broker, they must file a certain statement with the port where they have a permit with, which says I have so many employees, and this is the employee that I hire to transact customs business. Okay, so if your employer has done that, then the customs I'm on page 8. Okay, top of page 8. If your employer has done that and he gave you authority to sign documents, then you do not need to be a licensed broker. Of course, there is a caveat. What we see the trend where a lot of customs brokers, the employers, the big companies, right? If you go to, I don't know, Monster or Indeed.com or many of those job search agencies, you type in customs broker, okay? Many of the licensed customs broker, of the companies that are already licensed, they seek the prerequisite for being employed at that office is for you to have a license. And if you ask them, well, the customs license is not required for this type of responsibilities because I will be employed by you, okay? And the answer is relatively simple. It's mostly uniform. This is the custom within the industry. It is a basic entry prerequisite, and if you have a license, that means that you are a knowledgeable person, and I don't have to worry about other things such as watching over you all the time, or even though I do, okay, because your license will not be technically on file, but I will still I will be more at ease, if you will, by having a licensed person, because for them, for their employer, That shows that they are more diligent individuals. So if something goes wrong, they will always be able to come back to customs and say, look, I have 5 customs brokers who have their own individual licenses, and I went to the extreme length of hiring them, and just to make sure that I am conforming to the laws that you administer, okay? And this is a big mitigating factor if something goes wrong. And as we shall see, there are plenty of things that can go wrong in this business, all right? So we went over, if you're transacting in the customs business on behalf of yourself, or you are employed by the customs broker, you do not need a license, legally speaking, okay? Another thing is marine transactions, okay? Let's say you are, well, let's say in a yacht club, okay? And you're going from Ontario, from Toronto to, let's say, Buffalo, okay, by boat. All right, Canada, United States, okay. You bring the yacht, okay. This is a marine transaction, okay. This is also not license is not required for that. The next thing which we'll be discussing more, transportation inbound. Any carrier bringing merchandise to the port of arrival, or any bonded carrier transporting merchandise for another, may make an entry for that merchandise for transportation inbound. Okay, so some heavy stuff here. So let's say this is United States. This is Baja California, let's say, Baja. And this is the Mexican border. This is Texas. This is New York. This is, let's say, LA, okay? This is China right here. So stuff comes into LA, then it goes on a truck, goes to New York, okay? You want to clear things in New York, not Los Angeles, but New York. You want to clear things in Port of New York. So what do? Once it enters Los Angeles, you put it on transportation inbound. Inbound, what is bond? Bond means a security, okay? Bond means is a deposit if something goes wrong. It's kind of like insurance policy. They can access that insurance policy, okay? And carriers such as trucks, rails, okay? What else? Pipelines. I'm not sure about the pipelines, if they're required to be in bond, but the rails and the trucks are definitely the big ones. Sometimes the vessels, the inland vessels. This is mostly in Mississippi area too, because a lot of containers within the United States they get transferred through Mississippi Navigation Channel. All right, but let's say you want to clear it in New York. It comes to LA. You put it in bond. So any carrier bringing merchandise to the port of arrival, which is Los Angeles, or any bonded carrier transporting merchandise for another. So let's say this is China shipping, right? China shipping, steamship line. It brought to LA, and let's say I don't know, let's say UPS, okay? They do a lot of rail transportation. Let's say UPS transports this in inland, okay? So at the port of arrival, the carrier bringing the merchandise to the port of arrival, or any bonded carrier transporting merchandise, let's say UPS is bonded, may make an entry for that merchandise for transportation inbound without being a broker. So China shipping can make an entry for inbound transportation, and UPS can make an entry. No, but keep in mind, only for the inbound person, only to take it from point A to point B without taking it apart, selling it for consumption, or distributing it for the warehouse of FTZ zone. FTZ will cover separately. It's next. But for that purposes, you can do it. Can a customs broker do that? Yes. In fact, I see customs broker do that all the time. Okay, it can be done on form 7512, I believe, and can be done on 7501. So definitely customs brokers can do that. Okay, but if a carrier would like to do it on its own, they can do that too. Even though this is not their stuff, they're doing it on their behalf. So license for that is not required. Next. So we have non-commercial shipments. Okay, this is an interesting one. Let's say you have a friend. Okay, an individual entering non-commercial merchandise. Let's say I bring a box of wine. All right, and I know that a friend of mine, he is not a licensed customs broker, but he knows the stuff. Okay, and I bring a box of wine with me. If I do it through GFK, if you ever been to how many people been through GFK? Okay, international section, you know, you go through customs. Well, you know where the customs, actual customs commercial section sits? It sits in building 77. So if you are, so this is what it looks like if you're gonna make the entry. So let's say you go through terminal 1, okay? Depending on what terminal 8, okay, terminal 8. You come in with a box of wine, okay. Here there is a cargo section. There is building 77. These are the people who make all the formal and informal entries, who accept fees and things like that. So this means that that person, if they're gonna file a proper paperwork, somehow needs to get to building 77, then come back and get his box of wine. Okay, it's much easier to have someone who knows the local process to go to building 77 with the paperwork prepared, and then deliver this paperwork to the terminal if it's gonna be hand carried. Usually, box of wine is a bad example. Usually, it's done with jewelry hand carries, where you have small merchandise, which is usually carried by, it can be done in a small case, and it is usually transported with people. All right, I've seen freight forwarders, they have people who just sit on a plane and they transport high value stuff, diamonds, okay, jewelry. But that's commercial shipment. I'm talking about non-commercial for friends. If it's non-commercial, okay, it can be done, but there is a caveat to that. They have to have a power of attorney, which we should be covering next class. Okay? Power of attorney is a document that says, I give you the power to be my attorney, usually attorney in fact. Okay? So we have attorney at laws, we have attorneys in fact. Okay? So I give you the power to be my attorney for this purpose. So you can, on my behalf, go to building 77 and take care of all the paperwork, and then make sure my personal box of wine gets through. All right? Yes.
It's more in the transportation and bond. So when you're doing the transportation and bond,
Yeah.
the freight arrives into New York, and you submit your IT.
Yeah. So if you wanna do inbound shipment, okay, you're actually making two entries. First entry is the inbound entry. Okay. So very first thing you do, provided that you're bonded. I know it from the customs broker perspective. I don't know from the carrier perspective. I know for customs broker examination purposes, the only thing you need to know is that they can do this, okay, without being licensed. But let's say you're a licensed customs broker and you want to make an inbound shipment, and you want to make sure that that carrier, who is very good with moving stuff but not very good with the paperwork, okay, stuff, they call you up and they say, hey, can you cut an IT for us, or can you make sure we can deliver it from point A to point B? Make sure that everything is lawful. Okay, so what you do is you call customs at that port, let's say LA, you're in New York, and ask them to issue the IT number, immediate transportation number. Okay, they give you the number, you put that number on the paperwork, 7501 or 7512. If I'm saying 7512 and it is not, please don't kill me, because I may be wrong. But you fill it out and you put IT number on it, okay? Once it arrives to, and you submit it, okay? You submit it. If customs says okay, because it may also say not okay because it must go through examination. Let's say in LA they have some kind of message that it's a hazardous material, okay? So it must be put off to the exam site before they can release it, okay? But let's say you have an IT release, okay, with a rail or with a truck, okay? With rails it's usually easier. With trucks it can be pulled off. I've seen it pulled off in an examination station. So that's entry number one, authorized from LA to New York. Once it arrives to New York, you have to file another entry using that same number on 7501 usually, which is the entry summary. And you use that same number. If you don't use the same number, it's not going to work. Okay, you're going to get a rejection. And you use that 70 on one entry, number one, and use it on the second entry, number two, and this is a number where you clear it for consumption, let's say, 0 type 1 entry, okay? So with IT, the process itself is actually involved filing 2 times. First time for IT, second time for consumption or warehouse or for whatever. This is the mechanics. Does that answer your question?
Once your entry date, you would use the original IT date. If they say, what was your date of entry?
Date of entry is the date you file this. This is date of import.
Okay.
So this is date of import.
Okay.
This is date of entry. Okay? We should be talking more in details about that when we cover entry, but why is it important, date of import versus date of entry? Because if the duty rate changes, the duty usually goes not by the date of import, but by the date of entry, okay? But if I recall correctly, for when you do the IT, the date of entry is the date when the duty rate will be assessed.
Okay.
So this is a caveat which we should be covering, not the next class, but probably the class after next, these details, okay? But it's a good introduction. So the transportation inbound, the fascinating topic, we just got a head start. Okay, any questions on this, folks? No one? Okay, let me move on. Foreign trade zone activities. This is another thing that you do not need to be a license holder for. What is foreign trade zone activity? What is foreign trade zone? Anyone heard of foreign trade zones? Because I hear people back in the day, I used to think, when I was thinking about foreign trade zone, I was thinking about some boxed off fenced area where you cannot, if you enter, it's like another country, but except it is within the United States. Well, this is not true. What's the, and I can tell every one of you that you've been to foreign trade zone. Which one have you been? Well, how do I know that you've been to foreign trade zone? Because all of you said you've been to GFK. GFK is one big foreign trade zone. Okay? So, what are the foreign trade zone activities that you do not need a license for? Well, you can do certain things in foreign trade zone to take advantage of duty savings, such as, let's say you are the pharmaceutical manufacturer, right? Or the auto manufacturer or oil refiner, right? You want to bring a product in bulk and break it down into the pieces so you can sell for consumption. right? But you pay the duty based on the bulk. So let's say you bring you're the vitamin. Let's say you're Hoffman La Roche, a big pharmaceutical and vitamin company in New Jersey. All right, you are bringing big blocks of vitamins here. You pay zero duty or almost or very little duty because you bring it in blocks, unprocessed. Then you change it into the small tablets for consumption, pack it up in foreign trade zone, and bring it to the United States. Well, depending on how you structure a transaction, your foreign trade zone activity, which is breaking down big vitamin blocks into the smaller ones, once you bring it in, you pay duty only on a big block, not on a small vitamin. If you were to bring a small vitamin, you will have to pay a higher duty. Okay, so this is one example of activity which is beneficial. Another example, and we shall cover it. This is a preview again. We shall cover it in more detail. Is when you bring, let's say you are British Petroleum, okay, or Exxon, and you bring crude oil, okay. If you bring crude oil here, you may be subject to the higher duty as opposed to crude oil is duty free, okay. Let's pretend that crude oil is duty free. But if you bring petrol or gasoline, for which you put in a car, which is obtained through oil, right? It's higher duty, okay. So you bring it into the foreign trade zone, the gasoline. Then you break it, the crude oil. You break it down into the gasoline. You break it down into the diesel and other byproducts which are useful. And then you bring it to the gas stations and commerce of the United States. But the only duty you pay is you pay on the crude oil, okay, which is almost no duty. To my understanding, is duty free, okay. This is another example of crude or foreign trade zone activity, okay. Anyone knows IKEA? IKEA, this is a, yeah, they have lots of foreign trade zones. They have like there is a website that lists all foreign trade zones. Why do you think they need foreign trade zones? Because the furniture is subject to the high duties, including anti-dumping duties. So if you buy any bedroom furniture out of China, you can pay, I think, 194% for some of them, almost 200% for the wooden bed in your bedroom. So IKEA and to compete effectively, IKEA can make a structure for foreign trade zone, where foreign trade zone operator brings in wood from China and makes it into the furniture. That's an example. Okay, this will be another operations. And depending on the industry, it can have its own certain variations, but this is a very useful mechanism for the big boys. Okay, mostly if there is a rough figure, if you have like 100,000 or less in savings, it's not worth doing it. Yes, Sunny.
If the product manufactured in the foreign trade zone, are they made in USA considered? I mean, just
If they are foreign trade,
raw material from
let's okay, so
and complete the production in the foreign trade zone.
Okay.
Are they classified as made in USA?
I
mean, are they subject as the product?
Depending on the type of operations, okay, it's case by case basis. There is no like raw material, okay. You have to look at the value of production and the value of input, okay. If it's, let's say, slabs, okay, which are have been shaped, merely shaped, it may not qualify as made in USA. And speaking of made in USA, made in USA in itself is regulated by the Federal Trade Commission, not by customs. Okay, they have its own rules. So if you're gonna put a label made in USA, customs will enforce it, right? But the rules, you do not look into the United States rules. You look at the rules of the Federal Trade Commission, and this is something I think beyond our class. I mean, it's a good topic, but the transformation of merchandise under the rules of origin, this is something which we shall discuss later. It will be under the entry rubric of our portion. Okay, so this covers the foreign trade zone activities. This also, I think, is a good time to stop and have a break. Let's see, it's 10 to 12. We'll come back at 12 o'clock and we shall resume. And by the way, folks, remember I talked about spillover, because we're gonna do something at the expense of the other, sometimes the expense of classification. We will cover classification tonight, but I plan to take a little bit of time to finish up. We want to go through this completely. We got done about 1/3 of it so far, okay? And once we go through this, okay, we will get to the classification portion. So there will be spillover effect of this. Okay, see you in 10 minutes.